Hey everyone, welcome back to the channel. Hutch here from Sovereign Citizen Encounters. Today's hearing features a fresh-faced sovereign citizen who's about to learn the hard way that Judge Shackelford is not the judge you want to test. This one goes downhill fast, so let's jump right into it.
All right, this is 2509380M, the People versus Randall Crane. Are we ready on Randall Crane? Mr. Crane's coming up. Thank you, Mr. Kazicki.
No.
Mr. Crane, do you have counsel? Was that you, Mr. Barron?
Your Honor, Todd Barron, I did speak with Mr. Crane prior to the court calling the case today. I think that at this time, Mr. Crane's probably best served proceeding this on his own. There are some constitutional arguments that he's raising that I don't think as a member of the bar.
Oh, is he a sovereign citizen?
He's making some sovereign arguments, yes.
Okay, I have very little patience for him. I will let you know that, sir. So, okay, tell me your name.
My name is Randall Crane. That's a living name, not a corporate fiction.
So you're a real person, Randall Crane.
Okay.
Okay, now listen to me. Sir, you're here today because you have some charges against you. All right.
I'm challenging the court's jurisdiction.
Okay, well, denied. Your motion's denied. I have jurisdiction under the Constitution of the state of Michigan. What's your next? I'm not arguing with you, sir. I have jurisdiction. So
You have to provide subject matter jurisdiction as well
Okay.
as personal jurisdiction to me before you can proceed.
okay, your motion's denied. I have jurisdiction under the Constitution of the state of Michigan. What else? What else?
You do not have jurisdiction over the national.
I just said I did.
No, you don't.
All right. All right,
Okay.
so sir, do you want to proceed on these cases and talk to the prosecutor? Don't look on your phone while you're talking to me. If you
My
don't
notes
know-
are on.
No, you listen to me. If you don't know your sovereign citizen arguments well enough to come up here and say them, I can tell you can't have a phone in here.
In other words, learn your script.
I want you to listen to me. You're here today on misdemeanor charges. No talking. You're brought into court. You've already been arraigned. You have a charge of interfering with police officers in the while they're doing official business. That's a misdemeanor, punishable by up to 90 days in jail and a fine of up to $500. You also have a civil infraction for operating using a mobile electronic device, first offense. While operating a motor vehicle, a charge of no proof of insurance. Those are both civil infractions. Civil infraction for no proof of or no registration in a motor vehicle. So those are the charges against you, sir. I'm going to tell you the rights that are actually real rights that you have in this court. You have a right to an attorney appointed at public expense if you are indigent without money to hire an attorney, and if the offense charge requires a minimum jail sentence, or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense for an appointed attorney. You may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights. You have a right to, this is how trials work. You have a right to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. If you chose not to be a witness on your own behalf, the prosecutor could not comment on your refusal to testify. Lastly, you have a right to be presumed innocent unless you are proven guilty beyond a reasonable doubt. If you enter a plea, obviously you'd be waiving those rights. You also have a right to be released on bond. Now, it looks like you previously stood mute on these charges, so you're here today for a pre-trial. You have a few options, sir, under the law of the United States, the Constitution of the state of Michigan, and statutory law and court rules in the state of Michigan. You can either retain your own attorney to proceed on this case, or you can have a pre-trial with the prosecutor directly and try and work out an agreement, or we can set it for a jury trial. Okay, those are your options. You can get an attorney, use a court appointed attorney, but you understand that attorneys have an obligation to follow the law and not make frivolous arguments, which is what you want to make today. And if an attorney makes those arguments on your behalf, I could sanction them. So no attorney on this green earth is going to come in and make the frivolous arguments you're making on your behalf. Or you can speak to the prosecutor, or we can just set it for a jury trial. I don't want to hear it. I want you to pick out of those 4 options what you want to do. Hire an attorney, speak with a court-appointed attorney, talk directly to the prosecutor to work towards a resolution, or set a jury trial. Pick.
Let me ask you a question.
No, I asked you a question, and I'm telling you to answer it.
And I have the right to understand my rights and understand
Sir,
exactly
here,
what.
can you hand him this form? These are your constitutional rights I just read to you. Why don't you have a seat? You have a seat, read your rights, and I'll call your case back up.
I am asking for you.
Have a seat right now and read your rights.
Office.
I see contempt in his future.
Have a seat.
Have a seat right now and read your rights, sir. If you don't understand them, read them.
I'm moving for this court to dismiss. Have a seat.
Okay, well, that might never happen, but, what was that guy's name on that file? Because I'm assuming did he leave? Did he leave?
Yes.
He's big mad. Well, I need that file because I'm gonna give him a bench warrant. All right. All right. Are you okay, Amy?
Yeah.
I'm coming. I promise I'll get to you real.
RFK Jr. is correct. Fluoride in water has hardened a lot of brains.
I'm just, you know what? I know I should be more patient. I'm so tired of the sovereign citizen. All right, we're coming back up. This is 250-938-OM, the City of Taylor versus Randall Crane. Mr. Crane, you want to come back up? Mr. Crane, did you have a chance to go over your constitutional rights that I provided to you?
Yes, that's my constitution, right?
Okay, thank you, sir. So at this time, I gave you 4 options. Would you like to retain your own attorney? Would you like to speak with House Counsel and have an appointed attorney? Would you like to meet directly with the prosecutor? Would you like to set the matter for jury trial?
I'm going to be requesting for an order of change of venue.
Denied. Anything else? There's no basis for that, sir. So I'm asking you, we'll just set it for a jury trial, okay?
I have to understand everything in regards to my case.
Sir, I gave you your constitutional rights so that you could review them. I also gave you the attorney,
I understand
a
that,
court-appointed attorney to go over those rights with. So I gave you an opportunity to understand your rights. I'm not going to entertain, listen, I'm not entertaining your sovereign citizen arguments because they're unfounded and they're not legal. There's no legal basis for them. So I'm not doing it. So now I'm asking you, out of the 4 choices I gave you, which one would you like to do?
I am required to understand in regards to my case, including subject to jurisdiction matter.
All right, well, you could do your research. I'm setting this for a jury trial. We'll see you back for your jury trial on November 14th of 2025 at 9:00 a.m. I really recommend you retain an attorney prior to that date, sir, because I know I'm going to tell you what you're not going to do: waste the citizens of Taylor's time with your nonsensical arguments. You're going to come in. You're going to try your case. Again, if you want to talk to House Counsel, you can do so. All
I'm
right.
not wasting the city of Taylor's time.
Okay. Good. We'll see you on your trial date. Have a good day.
Judge Shackelford has officially run out of patience for sovereign citizens and will be seeing this guy again when he returns for his trial date. By the way, I covered his very first hearing on my channel. You can find the link in the description if you want to check it out. Now, let's head over to Magistrate Chisholm's courtroom, where a defendant with a simple speeding ticket decides to tell his version of events, but Chisholm has one of his own.
We have a Samsung. It's either going to be Mr. Wiggins or Mr. Walker. Let's see. Somebody signing up for a preview. Screen name Samsung. There we go. Sound. I'm Samsung. What is your name?
I'm Jonathan Wiggins. Your
ticket is 25 R03001. This is a speeding ticket that was issued on the 9th of May at about 1:30 in the morning. You're eastbound 11 Mile in Lafayette. You were cited 35 and a 30. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
Not guilty.
Raise your right hands, please. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
Yes.
The officer will testify first, please.
Your Honor, on the listed date and time, I was traveling eastbound on 11 Mile approaching Lafayette when I observed a black 2021 GMC Yukon traveling westbound on 11 Mile. Eastbound on 11 Mile when I activated my front moving opposite radar and got a reading at a 47 miles per hour and a 35 mile per hour zone. I also observed the vehicle moving at a very high rate of speed, and that's when I activated my radar. The radar was tested before and after my shift, and I am certified to operate radar.
Thank you. Mr. Wiggins? Sir?
You want to hear my statement, is what you say?
Yes.
Okay. I'm Jonathan Wiggins. I was coming home from work, 1:30. I take that route.
Lost sound. Who froze? Who froze? Make the sound. Do we have a phone number?
Your Honor, I'd like just to clarify something. I was traveling, I might have missaid something in my testimony, but I was traveling westbound, the vehicle was traveling eastbound on 11.
I don't know what happened, but it just cut off on me.
Yeah. Hope we got you back.
Okay.
So where it left off was, you said you were on your way home from work?
Yeah, I get off at 1:15, and I take 11 Mile every day. I know to do 35 miles an hour on 11 Mile Road and 45 miles an hour on Woodward. I don't have no reason to be racing up and down the street. I'm 60 years old. It was a car on the side of me when he was in front of us, facing us. And when he pulled me over, he said, "You know, you pulled me over for?" I say, "No, I don't." He was like, "You were speeding." And I was like, "Well, it was two cars. We were side by side on the lane, so how was I speeding?" And he said, "I visually radared you at 47." And I said, "Excuse me?" And at first, he didn't have a radar. When I read my ticket, it says that he used the radar. And then he said, "Well, I'm just going to give you a ticket for 1 to 5 over." I still take this route every day. I'm tiptoeing just to get to 75 so that I can get home. It's kids racing up and down Woodward and all type of sports cars. I'm not one of those. And I didn't like him saying that I was speeding, and it was just too much for me.
So the judge just dropped it from 12 miles over to 5, which is honestly a pretty solid deal. Of course, he's still not happy.
What's that got to do with the rate of vehicle?
I was doing 35 miles an hour on 11 Mile Road all the way to 75. I don't know how he clocked me at 47. It was two cars. It was me and another car. We were side by side.
Maybe both of them were speed.
Why does that show that you weren't going 47?
He was in front of us.
The officer was opposite direction.
Yes, he was facing us. Yes, coming from another direction. Then he turned around and got behind us. Got behind me, and I saw him. So I'm still doing 35 miles an hour down the street. Then he pulls me over. He had the time to read one car plate next to me, and he had a chance to read my plate. He pulled me over and said that I did 1 to 5 over, but I was really doing 47 or something. And I take this route every day. I work at the hospital. I have no need to race. I have a big Yukon truck It is not a race car.
That right there is another red flag for the judge. If your car is larger than the one next to you, the radar is going to lock onto the bigger or faster vehicle first. So by bringing that up, he basically just exposed himself without even realizing it.
And I don't drive it like that. I don't have any tickets for speeding or none of that. Never. I haven't had a ticket in almost 20, 30 years. So to hear this was kind of like, wow. So I'm saying I'm not guilty on the speeding charge down 11 Mile Road. I know the law on Woodward and 11 Mile Road. I do. And that's a chance you just speeding down 11 miles, doing 100 miles an hour to get to 75 is crazy. I would never do that.
You haven't had a ticket in 30 years. You see a ticket in St. Clair Shores in 2020 and a ticket in Highland Park in 2023.
Speeding?
He know what it's for.
No, a ticket.
Oh.
The one in St. Clair Shores was speeding.
1 to 5 over, was it like that?
Yeah. That appeers to be the case.
I'm a good driver, Your Honor, and I don't want to be
Civil infractions are not crimes. Civil infractions are mistakes. They don't involve an intent to do evil. If somebody's just driving down the street, it's not unusual that they could be speeding because the speed limits
very
set low. And if you're in a speed zone that's 25 to 30, and you're not thinking about your speed, you're just going from point A to point B, most of us could well be going faster than 30. Now, your speed was measured at 47 before the officer turned around to get behind you.
Allegedly.
Measured as you approach the officer.
He said he had it on radar, sir. He should be able to present that. I mean, he told me...
That's not the way radar works.
He told me he clocked me visually.
He told you that he measured your speed with the radar because he observed you to be speeding. That's what motivated him to operate the radar, to use the radar device to measure the speed of your vehicle.
He told me he visually clocked me at 40. But it's okay.
That's not the same. You're taking things out of context. If an officer sees a vehicle approaching and thinks that it's going faster than the speed limit, they're trained. They can give a visual approximation that is going to be pretty darn close. Research indicates that the visual observation speed, not with a radar, but made by an officer, is going to be about 2 miles an hour slower than the car is actually going. But the point is, the officer thought you were speeding. He didn't cite you for what he thought you were going. He operated the radar so as to measure the speed, and he found that you were going 47. You've got a decent driving record, to say the least, and in the exercise of his discretion, he elected not to cite you for the full 3-point infraction, but he gave you a 1-point infraction. He knocked it down to a 1-point event. He's certified to operate radar. The radar unit was checked both before and after his shift. It worked at the start. It was still working at the end of his shift. It didn't break and fix itself some point in the middle. So there's no finding here that says that you were intentionally speeding, but I do believe you were going 47, and that means at least 35. So I do think you're responsible for 35 and 30. That is the speed limit there, 30 miles an hour.
Yes.
And the fine for that is $130. $130 can be paid online or by mail, or you can pay it at the courthouse counter if you prefer.
Can I eliminate the points, Your Honor?
The points don't come from the court. They come from the Secretary of State. I can't change them.
And you say he checked his radar, not you, right?
Of course, they didn't check his radar.
Okay. He didn't have a radar, sir.
Yeah, he did.
He didn't use it. He told me he did not use a radar. It was
that's not what he said. He said he made a visual observation of the fact that you were speeding.
It was 2 cars. It was both of us. It was 2 cars.
That doesn't mean that either one wasn't speeding. If 2 cars are going the same speed, that means they're both going the same speed.
Yeah, so pull both of us over.
That's not practical.
Yeah, it is. I don't understand. I just know, you know what I really believe?
I
That
don't
he
think
got
I
a
want to
chance,
hear.
he got a chance to judge. And that's all I can say.
Because he's driving the opposite direction from you. He has no idea as to how many people are in a car or what they look like.
No,
This ticket
when he
is
turned
turns
around,
over.
It's always hilarious how Magistrate Chisholm just ends the call the moment defendants start rambling. Anyway, that case is wrapped up. Now we're heading over to Judge Hesling's courtroom, where a pro SE plaintiff is trying to play lawyer after dropping the ball at work. This guy filed a stack of ridiculous motions that make absolutely no sense. Let's jump in and see how it goes.
Next matter is Jeff Hodges versus Megan Sheldon. It's file 25-40686-GC. Who do we have present in this case?
Jeff Hodges. Good afternoon, Your Honor. Matthew Kassar, P83663, here on behalf of the defendant, Megan Sheldon.
All right, thank you very much. And do we have, who's ready? Anybody here for Jeff Hodges?
Yes, I'm here.
All right, I do see you now, Mr. Hodges. Thank you very much. This is a motion for summary disposition filed by the defense. I'm going to give each side an opportunity to tell me why they believe that their side should win. Counsel, go ahead.
Your Honor, just so I can clarify, I think today, I'm happy to go forward. We did file, Ms. Sheldon filed a motion for summary disposition. It is set for hearing July 14th. Just to comply with the court rules, the 21 days. This was the date and time set for a pre-trial. Again, happy to go forward with arguing the motion for summary disposition, but per the court rules, we had to set the hearing out 21 days.
I see that now. Thank you for bringing that to my attention. Mr. Hodges, did you understand what he just said?
I don't
All right. The procedure is if they file a motion such as he's filed called a motion for summary disposition, that is a motion that says we win by virtue of what the law says. They have to give you 21 days to respond to that, and that would be on July 14th. It's already set for a hearing then, so 2 weeks from now. However, if you want to, you could allow that to be heard today, and we would just cancel the hearing on July the 14th. If not, we'll probably just come back on July the 14th and we'll argue it then. What would you like to do, today or on July 14th?
I prefer to see what can be solved or not solved today.
Okay, so you want to go forward today and not have the hearing on the 14th, is that correct?
Yes.
Okay, all right. So I'm going to give both of you again an opportunity to argue your sides and to put out whatever information you want me to have. So counsel, this is your opportunity. Go ahead.
Yeah, thank you, Your Honor. This is, I trust that the court received the briefs and the motion. This is one of several actions filed by Mr. Hodges in the wake of his termination as a contract worker, ultimately for the end client Wade Trim Inc., which is a professional engineering firm. Mr. Hodges filed several actions that we believe are frivolous. This is one against Mrs. Sheldon, who was a remote supervisor of Mr. Hodges during his 3 or so weeks as a contract worker. Mr. Hodges was terminated for performance purposes, performance concerns. He was an at-will employee. He was actually terminated from it's called Act Talent, which is a staffing agency that Wade Trim uses to staff some of its engineering projects. This was filed initially as a small claims matter. There's a short affidavit, half a paragraph or so of allegations that are vague, conclusory, do not state a cause of action, and do not state any facts that would support any cause of action under Michigan law. So Ms. Sheldon moves under MCR 2.116C8 and 10. Mr. Hodges' claim, if there is a claim, if there is a cause of action, fails as a matter of law for all these reasons. There's an affidavit from Ms. Sheldon in support of the motion for summary disposition. And I will note, Your Honor, that because Mr. Hodges has not responded, ordinarily, in order to defeat a motion for summary disposition, you would need to respond with an affidavit or evidence of his own to rebut the arguments that are stated in our motion for summary disposition. That hasn't been done. Again, I'm not sure that there would be any reason to do that because, again, there's no cause of action. What it suggests is a wrongful discharge, but he was an at-will employee, not even an employee of Wade Trim. He was a contractor, and at-will employees can be terminated at any time for any reason or no reason. We go into our briefs, and I'll just be brief, no pun intended, but be brief. If there was a cause of action for fraud, that hasn't been pled because all the elements have not been established. If there's a cause of action for intentional infliction of emotional distress, that too fails under Michigan law. And if there was a cause of action for wrongful discharge, as I stated again, under Michigan law, that's not viable. For these reasons, we request that the court dismiss this case. That's it.
Sounds like the other party could really use an attorney for this one. Let's see how he decides to handle the judge's response.
Mr. Hodges, how do you want to respond?
First, I'm aware of the at-will law, but my termination is illegal because I'm a protected employee under the federal laws, and I clearly state so. Seems like the other end has problems of the comprehension, so that's problem one. So I filed a small claim lawsuit against Megan Sheridan for her deceptive action to lie to me for a meeting 2 hours away to drive that incurred significant travel expenses on the last day of the snowstorm here in Michigan. And potentially criminal activities has occurred because after I was unwilling to settle initially, someone in Wade Trim made a false accusation on me, accusing me as a terrorist, trying to get me arrested. And the police report is available in Kent County Sheriff's Office. And the CFS number is KSP-01231667-2025. But of course, the prosecutor see the contents is nonsense, so they declined to press the charge. And through this process of the bogus, faceless attack to fabricate me as the terrorist, online stalking has occurred. So as an additional discouragement of further actions like that, because someone in Wade Trim stalked me online, collecting information, and that includes the CEO of the Wade Trim. So I have to file additional lawsuits to the CEO directly himself to discourage future escalation of the harmful activities against me.
Your Honor, may I respond?
Sure.
So I want to respond to each point made. First, Mr. Hodges, one, did not plead that he's a protected class, and two, there's no evidence obviously offered that he would be a protected class. There's nothing that would suggest that he was anything other than an at-will employee. Also not an at-will employee of Wade Trim or Ms. Sheldon, who's the defendant in this case, which was just one of his remote supervisors. Two, he said he incurred travel expenses on the day that he was terminated. If he did, he was reimbursed for everything, and these proofs are in our papers, so that allegation does not hold any water. And three, the quote-unquote accusation of Mr. Hodges as a terrorist is not true. If you look at, I believe it's Exhibit 2, the Ms. Sheldon affidavit, Exhibit A to Ms. Sheldon's affidavit is a compilation that Wade Trim's Human Resources Department collected of Mr. Hodges' public LinkedIn comments that indicate that he is notorious for filing lawsuits and also has several threatening and violent comments against employers and supervisors and the like, which is why Mr. Hodges was reported to local law enforcement as Wade Trim's Human Resources Department was concerned for the safety of their employees.
Okay, he has secrets we don't know nothing about.
And as you mentioned, filing a lawsuit against the CEO, That is also a lawsuit pending before Your Honor, and we have also filed a motion for summary disposition in that case and seeking sanctions for filing frivolous cases against Wade Trim and its employees. That lawsuit obviously is not up for today. It's coming for hearing on July 21st, but we will be seeking the same dismissal and also costs and fees in order to have to defend against that case. In addition, Mr. Hodges filed a petition for a personal protective order against Mr. Andrew McCune, who's the president and chief executive officer of Wade Trim. This is also a frivolous filing, also requiring Wade Trim, Mr. McCune, and Ms. Sheldon to incur legal fees by way of a frivolous lawsuit. Again, there's no cause of action here. There's no facts that would support a cause of action, and it requires, and there's no evidence to rebut the now unrebutted evidence attached to our briefs that establishes that summary disposition in favor of Ms. Sheldon is proper.
All right. Mr. Hodges? What information do you have to support your claim that you are a protected individual under federal law?
In the email communication, it told, who was it, Megan Sheridan, that I'm a protected employee. And due to the underlying reasons for the protection, I need the reasons to notify them. And because of the email correspondence, since I was terminated because of this. And
I still haven't heard you tell me why you're a protected individual. What status do you have that would allow you to be protected under federal law?
I'm protected under American Disability Act due to various disability conditions. Thus, I have...
Such as what?
Such as this. So I need...
Have you submitted any of that documentation with your responses to this court so that I can determine whether or not you're a person that has a disability?
How should I submit the information?
Now, he's filed a bunch of frivolous motions, but he has no idea how to properly submit documentation for his disability.
You do it the same way you send in information on anything. You filed a complaint with this court. That's when you put in. That's how you put in the information. You drop it off at the court, or you mail it. However you got the original information here, that's how you get that here. So, have you submitted any documentation to support your disability claim?
They are here on my side, but not on your side yet.
Well, there's nothing I can do about it. You haven't submitted it. You haven't sent it in to the other attorney. You haven't sent it into the court. So there's nothing that I can look at to determine whether or not you actually have a disability claim there. Just showing me a pill bottle and papers doesn't do any good at all.
Given that situation, I do have some additional information here. I don't know how visible this is.
It's almost invisible. I can't tell what it is at all.
Okay, then I will not try that. Is there a way to request a hearing at a later date after I submit the information related to this?
Well, tell me what that information is going to be, and I'll make a decision about that. So, what is your claim for disability?
Because I informed them that I have underlying disabilities falling under ADA. And
that's a conclusion. That's a conclusion, sir. I don't want a conclusion. I want you to tell me what facts you have that prove that you have a disability of some kind.
Okay.
You have a doctor telling you that you have a disability.
Yes, I do.
And the doctor says that you can't work, or that you have limitations or restrictions on your work.
Yes. And
who is that doctor, and what are the limitations or restrictions?
I need accommodations in the hours so I can attend to the necessary medical appointments.
Who is the doctor, and what are the limitations?
Where my psychiatrist, like psych nurse, and my psychological therapist, Stafford, and I need additional psychological evaluation to make further determination of the condition, to make better treatment.
Then you don't have a disability if you need further confirmation of that. That you might want to go for a disability, but you don't have one right now. You have a disability from a doctor that says that you cannot work or you can only work with limitations.
I have that.
Where?
The disability is established, and it was diagnosed of me as early as 2018. And that's the record I always have, and that's the record I always inform the employers that I have a disability and I need that accommodation.
So that's step number one. So I'll keep that in the back of my mind for a minute to determine whether or not we need to have a further hearing on your disability. The next step is, even if you had a disability, how is Ms. Sheldon the one who fired you?
Where I told her I have a disability and I have to let everyone know I have a disability so the hours can be accommodated. And upon telling her so, I was terminated as a result.
Who were you working for?
I was working for Courtroom.
The defense has said that you were working for a temporary firm by the name of Activent?
Yeah, where I was working for Courtroom through firm, yes.
You might have been working at a Wade Trim job site.
Yes.
What evidence did you have to prove that you were working for Wade Trim?
Where the payroll comes from the firm that is Excellent, but I reported directly to Megan Sheldon.
I'm not asking who you report to. I'm asking who hired you.
Excellent.
Ms. Sheldon worked for Actilent?
I don't know who she works for. Probably with Trim or wherever the payroll comes from her.
Well, the defense has said that she works for Wade Trim and not Actilent. So if you work for Actilent, why should you be suing Ms. Sheldon?
Because Mr. Sheldon is the one conducted deceptive actions on me and terminated me.
She didn't terminate you if she didn't employ you.
Then I don't know how that works.
I think he filed a pile of motions that got all mixed up because he clearly didn't know what he was doing. Honestly, he should have had an attorney from the start. Even if he didn't have much of a chance of winning, at least someone could have kept things on track.
I'm sorry that you don't, but all I can tell you is you can't sue somebody for doing something that they can't do. If Ms. Sheldon is not your employer, she can't fire you. Your employer fired you. Your employer right now is Actilent, as far as I can tell.
Then they never fired me. They did not say they fired me. They just want to stay away from this problem, and they told me they didn't do anything until it gets pretty chaotic.
Then what's the problem? Why should I have a lawsuit against Ms. Sheldon if you were simply told to stay away? You're employed by Actilent. They can tell you to go wherever they want you to go, can't they?
No, so that's why I received the COBRA letter, so that shows that the termination of employment. Then because Megan Sheldon did the decision of termination, so
How can Megan Sheldon make a decision to terminate you if she doesn't work for Actilent?
I don't know. The termination decision comes from her in my perception.
Your perception doesn't mean a thing right now if she doesn't work for Actilent. You told me that you were employed by Actilent. The defense tells me that she's employed by Wade Trim. Do you have any evidence to dispute that?
I don't.
Okay, then. Based on that information, then it really doesn't matter whether you've got a disability or not. Your lawsuits against Megan Sheldon, there's nothing that she did or could have done that would be viable in a lawsuit if it's a termination of employment process. That's all through Actilent. You're gonna have to sue Actilent. Megan Sheldon's got nothing to do that. Counsel, did you submit a proposed order in this case yet?
Oh, we did not, Your Honor. We can submit one today, though.
All right. Please do so, indicating that I find for the defense for the reasons stated on the record, and I'll sign that once it's submitted here. Thank you very much. All right, that's all for today.
Thank you.
Well, employment means exactly that at will. When an employer hires you, they can let you go at any time, just like you can quit whenever you want. So, how do you sue a company you didn't even work for, claiming they fired you? That makes zero sense, but he's about to learn that lesson the hard way. Anyway, that's it for today's video. If you liked it, hit the like button. If not, hit dislike. Don't forget to comment, subscribe, and turn on notifications so you don't miss the next one. I'm Hutch and I'm out.